प्रॉफिट वो तकरीबन 4 अरब रुपया था और जो प्राइवेटाइज हो रहा था उसका 75% स्टेक वो $362 मिलियन था, जिसके अगेंस्ट एवज में वो 75% स्टेक जो है वो प्राइवेटाइज हो रहा था। ये पिटिशन आई और पिटिशन में सुप्रीम कोर्ट ने उस प्राइवेटाइजेशन को कलअदम करार दे दिया, गैर कानूनी करार दे दिया 184(3) में। 2009 में फिर एक एसएमसी हुआ, सो मोटो नंबर 15 ऑफ 2009, ये भी रिपोर्ट हुआ पीएलडी 2012 सुप्रीम कोर्ट 610।
पीएलडी
2012 सुप्रीम कोर्ट 610। अब ये जो 2009 में सुओ मोटो आया ये था रिगार्डिंग करप्शन इन पाकिस्तान स्टील मिल्स। अब प्राइवेटाइजेशन जो है वो कलअदम हो चुकी है 2006 में, और फिर उसके बाद 2009 में ये सुओ मोटो लिया गया कि जी बहुत करप्शन हो रही है वहाँ पे। जब ये सुओ मोटो लिया गया और एक फॉरेंसिक ऑडिट रिपोर्ट आई तो उस वक्त तक जो यानी 4 अरब रुपए के प्रॉफिट में थी 2005 में, सुओ मोटो 2009 में हुआ और अब 2009 में 26 अरब रुपए के लॉसेस में जा चुकी थी स्टील मिल। एंड 30 जून 2022 तक स्टील मिल जो है पाकिस्तान स्टील मिल अब तक एक्यूमुलेटेड लॉसेस 206 अरब रुपया हो चुका है। 206 अरब रुपया एंड काउंटिंग। नहीं, मैं आपको फैक्चुअल नहीं है, मैं जब ये बात कर रहा हूँ कि अभी की जरूरत क्यों है।
Do not respond to everything interjection. I cannot complete your sentence even.
इसकी 206 अरब रुपए का नुकसान हो चुका है 30 जून 2022 तक एंड काउंटिंग।
Basically, you are saying as a consequence of the actions of the Supreme Court in exercise of 184 jurisdiction. Is this the point you're making?
Yes. और उसका रिव्यू 2006 में
I don't know why we are so reluctant to hear the truth. I mean, let us
2006 में उसका रिव्यू फाइल हुआ। 2006 में रिव्यू फाइल हुआ उस जजमेंट का।
आप बढ़ते रहिए, चलें। हाँ।
This should not be against the Supreme Court.
It's not, but it is a fact. 2006 में उसका रिव्यू फाइल हुआ सर, और वो रिव्यू 2013 में रिजेक्ट हुआ 7 साल बाद। उस वक्त तक वो कलअदम हो चुका है और उसके बाद एक सुओ मोटो भी आ गया। दूसरा इंस्टेंस है रेकोडेक का।
नहीं, पहले जरा काइंडली इसकी रेलेवेंस बताइए।
इसकी रेलेवेंस सर मैं इन द कॉन्टेक्स्ट ऑफ
कंट्रोवर्सी एंड टू द कॉन्स्टिट्यूशनैलिटी और अदरवाइज ऑफ दिस एक्ट,
मैं आपको सर ये बताने की कोशिश कर रहा हूँ। दिस इज इन रिलेशन टू द एक्सरसाइज एंड दिस इज समथिंग दैट necessitated providing for this appeal constitutionality.
Were these cases discussed in Parliament? Because you haven't provided us the reports, or is this your personal opinion?
This is something which has happened over the years.
No, it may have happened. Nobody's going to get into that. The question is, were these cases discussed in Parliament? Were they discussed? Did they form the basis of why this law had to come? Because that's what we are hearing this case.
Referring the cases from Tamizuddin Khan case, वहाँ से लेके तमाम ये नुसरत भुट्टो केस और फिर ये रेकोडेक केस और सुप्रीम कोर्ट बार केस और ये फिर अकामा केस जो है और फिर ये हुदैबिया केस सारे लेके आप हमें ये चार्जशीट करना चाह रहे हैं कि सुप्रीम कोर्ट ने इन तमाम को देखने के जो को कॉम्पिटेंस नहीं थी उसने लॉ बना दिया और अब हम उसे लेजिटिमेट कर दें। यू वांट टू इन्वोक अस द डॉक्ट्रिन ऑफ नेसेसिटी टू लेजिटिमेट दिस लॉ?
नो सर, नो सर,
I think
मैं अगली बार जरा कंसीड कर लूं
मिस्टर अटॉर्नी जनरल। आई थिंक हमें थोड़ा सा हौसला रखना चाहिए सुनने के लिए तनकीद। आई डोंट थिंक यू यूज द वर्ड चार्जशीट। यू आर सिंपली स्टेटिंग अ फैक्ट एंड वी शुड हैव द पेशेंस टू हियर योर सबमिशंस। Your submission is, from what you have just commenced by stating, that 184(3) may have done some very good work as well, but 184(3)'s consequences have also been, I don't want to use the word disastrous, but maybe not so good. So you're just stating that Parliament does not have to mention each and every case, but this is the cumulative understanding. I mean, you don't have to spell out everything. Tamizuddin Khan was not 184(3), etc., but these cases were. So you are just stating a fact, and we should be sort of have the wherewithal to accept it. I mean, we were a council at some stage, and we are judges now, and we are citizens always. So if someone is historical fact to build the argument why 184.3 may have been given a right of appeal. So let us hear him with patience. And if you don't agree with that, by all means, write judgments, whichever you want to. But at least, please continue. I mean, otherwise we will be forever. I mean, you didn't do this thing. You are saying we did it. And you're just pointing, showing us the mirror. Fine. I have no problem to show me a mirror about all the judgments I've passed which are wrong. I have absolutely no problem. I would say thank you. I may learn from it and I won't commit the same error or mistake again. So please proceed.
Mr. Attorney General, the question still remains, which I've already put before you, whether the court did good or whether the court did bad, and beauty may lie in the eye of the beholder, and there may be people who say that was good and that was bad and that was not so good and that was not so bad, and we can carry on ad nauseum. This is not a debating society. We are not sitting here to receive a public lecture from you, sir. You are Attorney General. Kindly tell us what is...
If there was a remedy of appeal.
Sawal sun lein.
If there was a remedy of appeal.
What does that have to do with the...
These consequences could have been averted.
What does that have to do with the legislative competence of the
I have, as I stated, my lord, I've already made submissions to it. I am referring to what yesterday Justice Hilali...
If there is legislative competence, तो बात खत्म हो गई.
जी.
आप हमें ये दस क्यों दे रहे हैं?
ये इसलिए जरूरी है सर कि ये आपके पास अभी not long ago record date के ऊपर under 186 you had to come and protect what had happened.
Then the question that my learned colleague has asked you, that becomes relevant. आप हमें बात कीजिए legislative competence की.
Legislative
कन्विंस कर कीजिए कि आपके मुताबिक आप कह दें जी वो सब गलत कह रहे हैं, बात खत्म हो गई. I don't have to do anything, onus lies on them. You kindly tell us about legislative competence.
कल जस्टिस हिलाली ने एक कमेंट किया था, एक ऑब्जर्वेशन थी उनकी, उन्होंने कहा कि 184.3 जब एक्सरसाइज
Mr. Attorney General, I've been a counsel more years than I've been a judge, and I would always prefer that judges let me complete my submissions. They may not accept my submissions, hear my submissions, and discard my submissions. But certainly your right of making a submission, I think, otherwise we don't need to give you a notice, we can decide the matter ourselves. So please proceed in your own way.
While concluding,
दो चीजें देख लेते हैं जी. ये तो यहाँ तक everyone agrees that there were certain issues regarding 184 which agitated or which disturbed the executive, the parliament. Fine. Point taken. Second point, the law that you enacted, that law, everyone agrees कि ठीक है, law में कोई ऐसी चीज नहीं है, बाज यहाँ होगी, लेकिन वो law, no one said कि ये law जो है ये किसी तरीके से infringe कर रहा है आपके fundamental rights को as such, directly. असली जो main चीज आपने address करनी है वो है लॉ की आपकी जो लीगल कॉम्पिटेंस है, उस लेजिस्लेटिव कॉम्पिटेंस, आप प्लीज उस पे आ जाएं.
My lord, I'll come to the question that you had raised before.
आप अपने आर्ग्यूमेंट्स करें. My question, take it at the end. पहले अपने आर्ग्यूमेंट्स खत्म करें, like the चीफ जस्टिस just said कि भाई पहले उनको तो बोलने दें, आप जो आप बोलना चाहते हैं प्लीज बोल.
बल्कि सारे क्वेश्चन का जवाब आप बाद में दे दें, पहले अपने आर्ग्यूमेंट्स.
My lord, as far as provisions other than Section 5 are concerned, with regards to practice and procedure, I have submitted that the competence is drawn from Article 191, read with entry 58, and of course together read with 142A. 191 in itself acknowledges, recognizes Parliament's power to make laws with respect to practice and procedure. And the term law used in 191 does not in any manner exclude an act of parliament.
ये जो आप अगर एंट्री 58 को देखें, इसमें एंट्री 58 में आप किस उसमें आ रहे हैं? Within the legislative competence of Majlis Shura?
Yes.
Or relates to the federation?
First part.
Okay. And so your reliance on item 58 is directly dependent upon or flowing from your arguments that 191 confers legislative competence.
Yes.
Okay. Point taken.
So this is the conclusion or some of what I have submitted on as far as legislative competence with respect to matters related to practice and procedure are concerned. Now, and then comes Section 5, which is a substantive right of which has been conferred, and which obviously, at least in my my submission is that for that we have to go to entry 55, and entry 55, my lord, does two things. It empowers the Parliament to legislate with respect to jurisdiction and powers of all courts with respect to all the matters in the list, and to such extent as is expressly provided by or under the Constitution. And as far as Supreme Court is concerned, it empowers the Parliament to only enlarge its jurisdiction and confer supplemental powers on it. So it does deal with Supreme Court's jurisdiction and powers, but only to enhance them, not to curtail them. But as far as other courts are concerned, both things can happen, subject to what is provided by or under the Constitution, the language of the Constitution.
So once that jurisdiction has been enlarged, that act cannot be repealed.
My lord, I was thinking about the question that you
taken away.
You mean to say that enlargement of jurisdiction includes right of appeal?
Yes, yes, sir. Because this is the appellate jurisdiction of the Supreme Court, which exists in the Constitution, the appellate jurisdiction. It is that jurisdiction.
In fact, the
which
original
has been
jurisdiction has been enhanced. Under Article 184(3) is the original jurisdiction.
Original jurisdiction.
It has been enhanced by enlargement.
So my submission and my response to your question, my lord, is that nothing in Article 184 or 185 provide any extent to which they can be enlarged. Because they do not so there is no bar on the Parliament to the extent to which that jurisdiction can be enlarged.
Is there any limit of enlargement because the right of appeal has been given with retrospective effect? There is no cut-off date and it is open-ended. This question was also asked by me to Mr.
Yes.
Salahuddin,
Yes.
where it was not responded.
Mr. Attorney General, you have not given the details of express authorization that requires your...
My lords may note Article 2121, subclauses A, B, C, and then read with clause 2 of Article 212 with respect to administrative courts. It does both things. It provides to the extent to which those courts will function, the powers those courts will exercise, and then in clause 2, it then places limits as well, that no other court shall then exercise such powers. Thus, what this clause 2 does is places limits on the Parliament's power. The extent of authorization with respect to administrative courts is thus then covered under clause 1, A, B, C, and then
only
clause 2.
related to the administrative tribunals and courts. How this
So
is
all courts, sir?
helpful to you with regard to Section 5, which has been introduced under the new act?
वो अब इस पे मैं इसको जरा conclude कर लूँ इस बात को आगे. As far as article अब territorial jurisdiction, for example, of the High Court, वो extend हो
Section
सकती है.
5 is substitute of 185.
कि मैं उस पे आ रहा हूँ. मैं
उसको
भी
बताएं ना
वो
आप।
वाला part explain कर रहा हूँ जो सवाल था आपका कि कहाँ वो बताई हुई है by और extend.
नहीं, वो एडमिनिस्ट्रेटिव कोर्ट्स की बात
नहीं, मैं अभी जरा-
वी आर टॉकिंग अबाउट द सुप्रीम कोर्ट
जी मैं उसी पे ही वापस आऊंगा ना जब मैं ये कंप्लीट करूंगा.
विद रेफरेंस टू अपील.
जी दूसरी जो एग्जांपल है, दूसरा इंस्टेंस, नॉट एग्जांपल,
यहाँ
दूसरा
पे
जो इंस्टेंस है
मिस्टर सुलेमान,
192
यहाँ सवाल और भी ले लीजिए. जब आप 184(3) की अपील देख रहे हैं और लेजिस्लेचर ने या पार्लियामेंट ने महसूस किया कि यहाँ पे एक राइट ऑफ अपील होना चाहिए, तो फिर 184(1) की क्यों नहीं अपील दी गई? उसके बारे में क्यों नहीं सोचा गया?
जी.
Why only 184(3)?
I'll address this. आप आर्टिकल 192 क्लॉज 5 देखेंगे.
Mr. Attorney General, to add to that, if your argument was taken on its face value that enlargement is unrestricted and there is no limit given, then do you think by a legislative instrument 2 other appeals can be provided under 185? Let's say उनका जी एक अपील जो है वो 3 मेंबर बेंच ने डिसमिस कर दी है, उसके अगेंस्ट एक और अपील होगी जो 5 मेंबर बेंच सुनेगा, और वो अगर डिसमिस होगी है तो एक और अपील होगी जो 7 मेंबर बेंच सुनेगा. By definition, if there is no limit, then you're just enhancing, and you're enhancing through a legislative instrument. which finds no support from the Constitution.
Noted, my lord. I'll come back to this question. My lord, back to clause 5 of Article 192, which permits, through an act of parliament, extension of High Court's jurisdiction to areas beyond the provinces, which are not part of the province. So that is also...
You have already argued this point.
Ji. So this is also an instance where the extent is provided by which the express authorization is provided. Now, as far as enlargement is concerned, now if I may, my lord, you have a question?
I'm just waiting for the answer of retrospectivity.
जी, there are so many questions and there is so उसमें problem ये होता है my lord कि उसमें फिर कोई एक question miss हो जाता है and that is sort of unfair to the lordship and leadership of ask that question.
एक मिसाल मैं देता हूँ रईस साहब, बलूचिस्तान में पहले प्रोविंशियली एडमिनिस्ट्रेटेड ट्राइबल एरिया होते थे जो अभी अमेंडमेंट के तहत खत्म हो गई, तो हाई कोर्ट की जुरिसडिक्शन वहां तक स्पेशली एक्सटेंड की गई थी. इनिशियली देयर वाज कोर्ट हैड नो जुरिसडिक्शन, देन सब्सिक्वेंटली इट वाज एनहांस्ड.
उस पे तो कोई बार नहीं है.
तो वो एक्सटेंशन उस सूरत में होती है हाई कोर्ट.
जी जी,
जो आप कहते हैं हाई कोर्ट की जुरिसडिक्शन टू द एरियाज व्हिच डज नॉट फॉल विद इन द प्रोविंस, उन एरिया तक वो जुरिसडिक्शन रहती है.
Yeah, so this is an authorization under the Constitution through an act of Parliament. My lord,
ये पहले retrospectivity की जरा जवाब दे दें.
retrospectivity to enlargement.
Yes, please continue.
Have I addressed your question? I have not.
I'm in no rush. Take your time. Take your time.
My lord, my lord, as
Mr. Attorney General, answering a question and us finding your answer appropriate are two satisfactory are two different things.
Two different things.
So we may not agree with you.
Yes. I'm just hoping that I can persuade the majorities. That's the
Should hope to everyone.
No, I want to persuade everyone, but because we are in full court.
That's a very lawyer's remark. Majority.
But after arguing for all of us put together. No, I understand.
As Attorney General, you should say I should be able to convince the whole.
No, because on full court, I have to go back to ladyship, so it is part of that. Retrospectivity. Now, my lord, I see the concern that my lords have on applying this law retrospectively and thus opening sort of doors to perhaps a lot of litigation. My lords, there are several cases, many cases which are no longer live issues.
Before you even address this question, does this law state explicitly whether its application is prospective or retrospective? Does it state so?
Subsection 2 of section 5, my lords.
Yes.
जी पढ़िए.
Is the right of appeal under subsection 1 shall also be available to an aggrieved person against whom an order has been made under clause 3 of article 184 of the Constitution prior to the commencement of this act.
Prior to the commencement. So its application is retrospective.
Yeah. So,
and it excludes any order passed under Article 188, where a review has been decided.
Does it attend to what my lord is observing?
my lord,
No, does it, first of all, before your opinion, does the statute say anything or it's silent on it?
it is silent on what happens if or what happens to the cases against which reviews were filed and
if it
decided.
is silent, it may not be appropriate for us to comment upon it. Or should we comment upon it?
My lord, if in my submission, because this might affect the people or the appellants, if this law is upheld and declared intra vires, who may come before you relying upon this provision, and at that stage you will have to decide the maintainability of that appeal on the basis, which is to say whether a remedy of review, if it has already been exercised and not
After hearing that party,
yes,
who is not before us.
who's not. So that is why, my lord, if you permit me, that I do not make any submission as far as the proceedings which may have culminated into review and having been decided. So that is.
And what about the effect of the law?
What about-
When it will be effective, from the date of its promulgation or with retrospective effect?
Now, my lord, the language of subsection 2 is broad. It says prior to the commencement of this act, which then means, what it means is that, it go back in time and apply. Now, there has been at least one example and several others as well, but the National Accountability Ordinance, for example, Parliament chose to apply it from 1985, and in Asfanjar Wali, my lords found it to be constitutional. So my submission is that, and this is something that I'm not stating on the basis of any data before me, I mean, I have no way to find out whether the case is decided under 184.
Do you remember any law? Do you remember any law in which the right of appeal was given with retrospective effect in our country?
Top of my head, I can't. I think.
Isn't it the principle, I may be wrong, correct me if I'm wrong, if it's a beneficial piece of legislation, its effect may be retrospective, but if it casts onerous obligations on the subject, then it is always construed prospectively. तो ये principle है.
Principle है जो retrospective application से laws की, otherwise if it is to the detriment of any party, ये principle applies.
So that is the branch of curative legislation.
So
You see,
when my lords,
it happens in curative legislation.
yes.
If the legislation is curative. But it is new law. You see,
My lord,
we have not made
I think-
any amendment in the previous law. This is new law.
I think it's again, I think it will turn on something which if it has become a past and closed transaction in the sense that it is no longer a live matter, my lords may
Mr.
decide
Attorney
it
General, I
due
am
course
again
of
not very
proceedings.
happy with this phrase or concept or idiom or legal concept of past and closed transactions. This is something also which has been determined, evolved by this court, or it is a jurisprudential principle of a well-established jurisprudential principle of past and closed transactions.
My lords,
Can I add a small question?
Yes, of course.
Where a right of review has been exercised, does it takes away the right of appeal if the same is provided by the statute?
Your ladyship, a very important question. I think if I may, it does not. I mean, the grounds are completely different. Review is very narrow.
Or even if I think that's a valid question. एक जरा से इसको मैं rephrase कर दूं. An order has been passed. A person thinks, he simultaneously files both review and an appeal. Just to err on the side of caution, he thinks that, or she thinks that order can be reviewed because some error on the face of the record. But being very cautious, also simultaneously files an appeal. So if the review is not maintainable, it doesn't mean the appeal goes away or vice versa, which it's an interesting thought which ladyship has put forward. I just was developing the thought.
Doctrine of election will perhaps apply in that case. I mean, if it is exercised when both remedies
Doctrine
are available.
of election is available when two remedies are before you. Doctrine of election
when
comes
both
when
remedies
both
are
remedies
available.
are available.
Yes, that's what I said.
But in this case, if the subsection 2 is sustained, then the persons who have already attempted for review and their reviews have been dismissed, they may also come and say that the right of appeal is a greater right than the review. So we are also entitled to file the review because this has been given with retrospective effect.
They may, sir.
Yes,
They may.
and they will be right
They may, sir.
if they do so.
Yeah.
No, in my personal opinion.
That is what I think my lord would be dealing with when those matters or when any such matter comes before your lordship.
Speaking for myself, I think the language used by the legislature is very clear, and it does not relate to an order passed under Article 188. So it's only when an
My
order
lord,
has
to
been
that
passed.
extent, if I may submit, my lords may give this finding if this law survives, and if any matter comes before your lordship, my lords may give a finding. I mean, there would be a question of maintainability of that
For
appeal on
instance,
that.
I'll give you a hard example of an actual case, which I believe there is some challenge to it. There is the famous case of the Prime Minister of Pakistan, Zulfikar Ali Bhutto case, where the matter was, a decision came by the Supreme Court where minority acquitted, majority maintained the conviction. Then came the review in which the minority joined hands with the majority and dismissed the review because the scope of the review was very extremely narrow. Surely we are not faulting the judgment of the minority who joined hands with the majority. However, if this law existed then surely that would say that our limited jurisdiction has now been expanded to an intra-court appeal jurisdiction, and now we can do so. So this is an actual case where the review usually doesn't happen, that the minority joins hands with the majority in dismissing the because its scope is limited, and this case is an actual case, and this, suppose this intra-court appeal right then existed, then surely the fact that the review was dismissed would not have, in my opinion, closed the doors to an appeal. How would you like to comment on that?
My Lord, I bow before your Lordship, but as I said, I think this is something which can be addressed in due course if a matter comes before
Mr.
you.
Attorney General, that was entirely on different premises because the original jurisdiction was exercised by the High Court, then appeal was before this court, and subsequently there was review.
I completely agree with my learned brother, but I'm saying suppose you can still say a review not maintainable because, I'm just giving you an example, of course that was not a 184 case, but I'm saying there could be a case where I say, sorry, no case for review made out, but it may be a case for appeal still. I don't know.
Review आपकी dismiss हो जाती है for non-prosecution.
इलेक्शन का
अगर फिर अभी वो उसका देखिए, I think we should not touch this.
नहीं, और उसमें ये होगा कि सर वो doctrine of
We
election
should
जब
leave
एक
this
application
we should leave this aside because actual cases may come up before us if we sustain the law.
in future, if the law is intra vires, and of course, both remedies will be available, an appeal under Section 5 and a review under Article 188, whatever the litigant elects first becomes his remedy and is precluded from exercising the other.
Okay, so we are in Section 5.
Yeah.
Now, I have a question. Section 5 and this entire law relates to practice and procedure. So,
Section 5, sir?
no, the entire law.
Yes, the rest.
Section 5, we are conferring jurisdiction, appellate jurisdiction, which is by all intents and purposes and by all definitions a substantive.
That's right.
How do you bring it within the purview of procedural law to provide a substantive right?
My Lord, a law may provide for, a law may provide for both the procedure and may contain some substantive provisions. What my lords had just observed, what has to be seen is whether there is legislative competence that exists for both. So my respectful submission, my lord, is that there is legislative competence for sections 1 through 4 and 6, 7 and 8 under 191, and then there is legislative competence under 55 for section 5. So both on that plane, the law we do not, the law can survive so long as there is independent legislative competence for both substantive provision and procedure.
At this stage, Learned Attorney General, how you respond to the objection of the petitioner that constitutional amendment was required for section 5?
My lord, as I just submitted that the entry 55, my lord, permits the Parliament with respect to Supreme Court to do two things, which is enlargement of its jurisdiction and conferring of supplemental powers. So the language which says except the Supreme Court, what it does is it requires the Parliament to limit its legislation only to this extent, which is to say that Parliament cannot reduce the powers which the Constitution confers upon the Supreme Court, because the Supreme Court's powers are all provided in the Constitution. Unlike high courts, for example, where the original jurisdiction flows from the Constitution, but the appellate review, revisional jurisdiction, or original jurisdiction on civil side under various statutes flows from entry 55, Article 142A with entry 55.
So, Attorney General, just a question on...
It does not change the language or structure of 184.
My Lord, in completing my submission on enlargement, because there is authorization, there is permission to enlarge jurisdiction, and there is no restriction in 184 or 185, by extending 185 to judgments and orders which are rendered under 184.3, therefore, a legislation on the basis of entry 55, enlarging the jurisdiction of this, appellate jurisdiction of this court and applying to judgments and orders under 184.3 is permissible.
So, coming back to my question, going by your thesis, then what is to prevent the Parliament from providing a second and third appeal in 185 through legislative, ordinary legislation, that we are extending the jurisdiction of the court by extending second, third, fourth appeals?
My Lord, in future,
Short answer, maybe, with respect. When that happens, we look at it.
I think let the attorney...
No, yes, but I'm just saying.
My Lord, my submission to that would be, for now, this is the first appeal which is being provided under 184.3.
No, आप principle settle कर रहे हैं ना कि आप extend कर सकते हैं एक constitutional appeal by ordinary legislation. So, I mean, by that token, if the Parliament tomorrow wants to provide second, third, fourth appeal, can it or can it not?
My Lord, if I may,
मैं सिर्फ उस
मैं अपनी थॉट्स को जरा अपनी सबमिशंस को
does it have legislative competence to do that or not?
जी साहब, अगर आप 185(2) पढ़ लें तो शायद आपको जवाब मिले. 185(2) कॉन्स्टिट्यूशन से एन अपील, मीनिंग एन का क्या मतलब?
नहीं होगा नेक्स्ट टाइम.
क्या दूसरे अपील?
The question is different. The
My Lord,
question is
if I just give my submission in form of a question, that if through a constitutional amendment,
I'm not talking of constitutional amendment.
I'm just if through a constitutional amendment, if the Parliament had provided under 184.3 that there would be a first appeal and then narrowing the scope of this and a second appeal, narrowing the scope of that second appeal as it is provided in its, let's say, if it was done
Counsel, I take your point. My question is very, very simple. One, you say, in terms of item 55, you can enlarge the jurisdiction of the Supreme Court and there is no restriction on how far, how much, and since when. So by that token, it has untrammeled, unrestricted powers to enhance and enlarge jurisdiction of the court. So, tomorrow, if the Parliament wants to provide a second and third appeal, on your premise that there is no restriction, they can do that by saying we are enhancing the jurisdiction of the Supreme Court. Now onwards, in 185, there will be a second appeal, a third appeal, a fourth appeal. Can they jurisprudentially, are they competent to do that? And if they are, then say yes.
My Lord,
So if I could just jump into this discussion, I think it's a very pertinent question and perhaps it might be subject to judicial review later on. But just a related question would be that when we read this, because this thing is slightly important to understand, this to such extent as expressly authorized, one reading of it shows that the word expressly was also underlined earlier. What does it mean? So to such extent is expressly authorized. So it means that there could be a possibility that it is not authorized. I mean, there is no extent given. Extent to such extent means that there might be an extent, but there might be no extent. So there could be situations where there is no extent, no express authorization is given, and the field is open.
Yes.
What do you say to that? I mean, it's not as if every provision, every jurisdiction will give an extent. As long as there is an extent, then Parliament is going to be regulated by that. But if there is no such extent expressly authorized, what do we do? I mean, then it's an,
if my lords may kindly
Constitution
turn
has
to-
not provided that extent.
My lords may
So
kindly turn-
a Constitution then allows the Parliament to.
My
go
lords
ahead.
may kindly to Article 203 Clause 3. This will answer my lord's question. 203 Clause 3.
Yes.
Now this says the court shall have such other jurisdiction as may be conferred on it by or under any law. So this then leaves it open to go as far, which the Federal Sharia Court can perhaps do. And then when you look at Article 199, Clause 1, it does not provide any extent to, there is no authorization to what could be done with that jurisdiction, but
if you say, what you're saying is, now you're contradicting the whole premise of your case. अगर फेडरल शरीयत कोर्ट में ये प्रोविजन दी गई है तो यही चीज तो सुप्रीम कोर्ट के साथ भी होनी चाहिए थी। अगर हम आपकी बात माने तो फिर तो दिस प्रोविजन जो आपने अभी
ये एक्सटेंट ऑफ ऑथराइजेशन है ऑफ ऑल कोर्ट्स, सो फेडरल शरिया कोर्ट इज ऑल कोर्ट्स, तो सुप्रीम कोर्ट की हद तक तो वो अप्लाई नहीं करेगा।
नहीं, हम जो चीज आप जो देखें ना, ये कॉन्स्टिट्यूशन ने क्लियरली स्पेसिफाई कर दिया, तो अगर आपकी हम बात माने तो यही चीज सुप्रीम कोर्ट के साथ भी उन्हें स्पेसिफाई कर लेना चाहिए था कि आप जुरिस्डिक्शन को कर सकते हैं ना।
माय लॉर्ड, ये इसका
नया जुरिस्डिक्शन,
बिकॉज विद रिस्पेक्ट अदर कोर्ट्स, respect to all other courts, and my lord will bear in mind that this Federal Sharia Court was an insertion later in time through 8th Amendment. But with respect to all other courts, the Parliament, the Parliament's power to legislate with respect to their jurisdiction and powers is broad. But with respect to Supreme Court, and this is the question that you had, that it begins by saying except the Supreme Court and then goes on. And what I submit is enlargement of jurisdiction and conferment of supplemental powers. With respect to Supreme Court, Parliament can only enlarge.
That point is taken that we read this extent with the upper portion, but suppose if we were to even read it with the other, what the reading of it shows that to such extent, the extent must be provided expressly in the, suppose it's not provided, then what do we do?
Right. So if there is, if
184 doesn't give any extent of its jurisdiction.
My lord, then because it says to such extent as is expressly authorized by or under, then what it does is that only, I mean, one reading of it is, and this is what my Lord Justice Ijaz has held.
If I may follow up on that question, there is perhaps another way to look at it. Suppose the word expressly were not there. Suppose it said to the extent authorized by or under the Constitution. Then the possibility could arise that this could mean either express authorization or by necessary implication. Perhaps the insertion of the word expressly is targeting the possibility of removing, of there being no possibility of any authorization by way of implication, howsoever necessary it may be. Expressly means expressly, full stop.
And if
all implications are cut out on by use of this word.
Right.
Had this word not been used, then we would be back in our traditional approach, expressly or by necessary implication.
And for example, just giving an example, clause 5 of Article 199. Now, this is the power of the High Court, where the High Court can issue writs, and the definition of person then excludes certain persons. The Supreme Court, no writ can be issued to the Supreme Court.
No, but
and
that's an exclusion.
Yes.
मैं तो बात कर रहा हूँ ना कि expressly अगर ना हो तो आप उसके अंदर someone could argue कि भाई जो normal तरीका होता है कि और courts के कई judgments भी होते हैं expressly or by necessary implication, तो वो principle शायद apply हो सकता है, but जब expressly कह दिया तो implication खत्म होती है। आपने express words दिखाने है या नहीं है, no matter how necessary it may be,
that's
the
right.
implication is out. Maybe
that's
that's
right.
one reason.
That's right. And that's why
What is your take on it?
जी मेरी take उस पे ये है कि
I'm
that
not
is
saying
why
it as I'm asking you a question.
जी
What's your
इसलिए
take on
I
it?
go back to what I was submitting with regards to entry 55, that the language list and to such extent as is expressly authorized by or under the Constitution is with respect to all courts. But for the Supreme Court, it is only enlargement and supplemental powers. And when we read it,
मैं आपसे पूछ रहा हूँ एक्सप्रेसली से डालने से, वो एक्सप्रेसली तो आप भी आपकी इंटरप्रिटेशन पे भी एक्सप्रेसली तो सुप्रीम कोर्ट को लगता है ना?
नहीं लगता है सर. That's what I'm saying.
के मुताबिक नहीं लगता.
नहीं लगता. That's what I've been arguing. कि सुप्रीम कोर्ट को नहीं लगेगा. सुप्रीम कोर्ट के लिए, बिकॉज सुप्रीम कोर्ट का जो सुप्रीम कोर्ट की हद तक
नहीं, हाई कोर्ट्स और बाकी कोर्ट्स को लगेगा.
इसलिए क्यों कर्टेल कर सकते हैं?
वहाँ पे आपकी इंटरप्रिटेशन के मुताबिक एक्सप्रेस होना चाहिए.
यस.
और आपने एग्जांपल दी 192 की और उसकी
मैंने 212 की दी एग्जांपल. एडमिनिस्ट्रेटिव कोर्ट
में तो एक्सप्रेस ऑथराइजेशन तो नहीं है ना.
नहीं सर, 212 के अंदर तो ये बता दिया ना टू व्हाट एक्सटेंट A, B and C, and then वहाँ ये भी बता दिया कि
आप कह रहे हैं ट्रिब्यूनल्स,
एडमिनिस्ट्रेटिव कोर्ट्स एंड ट्रिब्यूनल्स. एंड 199 का फॉर एग्जांपल 199 का ये कह दिया कि
ट्रिब्यूनल्स के हवाले से अगर आप देखें ना, ट्रिब्यूनल्स के हवाले से आपने एंट्री देखी है
जी, एडमिनिस्ट्रेटिव कोर्ट्स एंड ट्रिब्यूनल्स. यस,
वो भी तो एक एंट्री है ना.
जी बिल्कुल.
वो 212 के लिए तो एक्सप्रेसली जरूरत ही नहीं है, वो तो एक स्पेसिफिक एंट्री है.
ये Learned Attorney General,
for federal subjects, yes.
as I understand, this is in the context of curtailment of jurisdiction as well. Supreme Court, this entry itself, it is part of the Constitution and it expressly authorizes the Parliament to enlarge its jurisdiction. This in itself is an express authorization. So you don't even have to look anywhere else. This in itself is an express authorization to enlarge the jurisdiction.
ये आप जो jurisdiction की बात कर रहे हैं, एक पॉइंट जरा आप लोगों आपने इन पासिंग कर दिया फेडरल शरीयत कोर्ट का और शरीयत अपीलेट बेंच ऑफ द सुप्रीम कोर्ट का. अगर आप इस पे अगर आप ज़रा ज़्यादा गहरी नज़र रखिए तो जब ये अदालतें बनाई गईं, ये इख्तियारात जो थे अदालतों के पास उनसे ले लिए गए. अगर आपको याद है वो जो इंटरेस्ट को स्ट्राइक डाउन किया था सिंध हाई कोर्ट ने, वो सिंध हाई कोर्ट ने ओरिजिनल सिविल जुरिसडिक्शन में किया था. तो यहाँ तो जुरिसडिक्शन हाई कोर्ट की और सुप्रीम कोर्ट की ले ली गई, क्योंकि ये कहीं नहीं लिखा था कि हाई कोर्ट और सुप्रीम कोर्ट अगर कोई कानून कुरान और सुन्ना के तसादुम में है तो उसको स्ट्राइक डाउन नहीं कर सकता है. तो वो जुरिसडिक्शन तो ली गई, ठीक है. ये वहाँ तो कोई एंट्री नहीं थी, कोई फेडरल लेजिस्लेटिव लिस्ट नहीं थी. मगर अब देखिए फिर वही बात आती है तारीख की. वो काम जो एक जबर से होता है और मार्शल लॉ एडमिनिस्ट्रेटर जिसका इस्लाम में कोई कॉन्सेप्ट ही नहीं मौजूद है, वो तो हम देते हैं. फिर हम उसको सिर्फ इस तरीके से बचाते हैं कि कॉन्स्टिट्यूशन अमेंडमेंट एक्स पोस्ट फैक्टो हो गया है, ठीक है. उसके तहत नहीं आता है, वो एक जनरल उसमें आ जाता है और वो एक हिस्सा बन जाता है आइन का. मगर अगर आप शुरू में देखें, वो तो इख्तियार छीने गए थे ना हाई कोर्ट से और सुप्रीम कोर्ट से. उनके मकासद क्या थे वो दूसरे थे, वो मकासद में भी नहीं जानते. मगर इख्तियार बढ़ाए तो नहीं गए थे, वो इख्तियार थे हाई कोर्ट के पास और सुप्रीम कोर्ट के पास, जिनको छीना गया और वो सराहा गया. क्यों? क्योंकि देखिए मुश्तरका सोच आई पार्लियामान से, ठीक है. यहाँ तो हम इतनी बारीकियों में, बार बार मैं कह रहा हूँ, इतनी बारीकियों में जा रहे हैं. कभी कभी ये बारीकियों की बात उधर भी कर लिया करें, उधर तो एकदम सब लोग एक साथ हो गया, ठीक है. अब वो क्योंकि बचा कैसे, वो 269, 70, 78 जो भी हैं उनसे बचे हैं, उनके तहत नहीं आए थे. तो उनको आप ऐसे बार बार जो मिसाल देते हैं ना फेडरल शरीयत कोर्ट की, तो वो भी तो पावर छीना गया था हाई कोर्ट से. यहाँ तो सुप्रीम कोर्ट से कोई पावर छीना नहीं जा रहा है, सुप्रीम कोर्ट को एक मजीद इख्तियार दिया जा रहा है. अगर आप सुन लीजिए, अपील नहीं पसंद है डिसमिस कर दीजिएगा. तो इसमें मुझे वो इनलार्जमेंट और आइन में तरमीम की बात, तो वो तरमीम और आइन तो हमने उस वक्त तो देखा नहीं. उस वक्त तो हमने कहा जी ठीक है, क्योंकि एक जाबिर ने कर दिया तो पूरी इस्लामी मुमलिकत खामोश रहे इस बात पे और उसको सराहे, क्योंकि हम तो पता नहीं फिर हमारे फिर दीन और ईमान और ये सारी बातें कहाँ चली जाती हैं। ये देखिए, ये ऐसी एक चीज़ को आप पकड़ लें बीच में से और कोई हिस्टोरिकल कॉन्टेक्स्ट ना दें और क्या बस जी लेटर पे चलेंगे, तो वो मुझे बताइए कि उसको फिर जस्टिफाई आप कैसे करेंगे। जो जुरिसडिक्शन ले लिया गया था किस फेडरल लेजिस्लेटिव लिस्ट के तहत लिया गया था, कैसे लिया गया था, वो तो एक पूरा एक अलग उन्होंने पैरेलल सिस्टम खड़ा कर दिया। जो इख्तियारात ऑलरेडी मौजूद थे, आप समझ रहे हैं बात को।
अच्छा, चीफ साहब का सवाल हो गया, उनके बाद मेरे सवाल का जवाब दें। आई डोंट नो वेदर इट्स अ क्वेश्चन। ये आर्टिकल 191 स्टार्ट होता है सब्जेक्ट टू कॉन्स्टिट्यूशन एंड लॉ. So the powers of the Supreme Court in terms of making rules for conducting its own procedures have been made subservient to the Constitution and law. तो कॉन्स्टिट्यूशन में तो वो 239 आर्टिकल के नीचे पाबंदी उस पर लग जाती है, बट व्हेन इट सेज लॉ तो आई थिंक द डोर्स हैव बीन ओपन्ड कि कानून साजी जो है वो एक पार्लियामेंट ही कर सकती है ना। तो क्या वो 239 की पाबंदी यहाँ पर रह जाती है कि अनलेस देयर इज अ 2/3 मेजॉरिटी इन द काउंसिल ऑफ द टोटल मेंबरशिप ऑफ द पार्लियामेंट, तो आप अमेंडमेंट नहीं कर सकते कॉन्स्टिट्यूशन में। लेकिन जिस आर्टिकल में ये वर्ड्स लिखे गए हों, प्रॉब्ली उसमें आप कर सकते हो कि जहाँ पे पाबंदी है कि कॉन्स्टिट्यूशन को 2/3 मेजॉरिटी के बगैर आप उसको अमेंड किसी भी आर्टिकल को नहीं कर सकते। लेकिन इसमें लॉ को शामिल किया गया, तो लॉ तो वक्त के साथ साथ बदलता जाता है, उसमें अमेंडमेंट होती जाती है। तो डोंट यू थिंक दैट द बार ऑफ आर्टिकल 239 हैज बीन made flexible under this article?
Leadership, to the extent of practice procedure, there is no bar, there is no requirement.
What is constitution is there? That means subject to the constitution unless there is a 2/3. But when it says law, that means the law is enacted by the parliament. तो वो दरवाजे खुला छोड़ा हुए हैं।
वो practice and procedure के लिए वो limitation नहीं है जो पिटिशनर्स ने आर्ग्यू भी किया है, एटलीस्ट टू द एक्सटेंट ऑफ, खैर उनका आर्गुमेंट तो एंट्री 55 पे प्रैक्टिस एंड प्रोसीजर पे तो इंडिपेंडेंस ऑफ जुडिशरी का था।
मेरे ख्याल में आपके आर्गुमेंट्स को मैंने क्रूजे में बंद करके आपको दे
थोड़ा सा मैं ये ऐड कर दूं उसके अंदर कि जो 191 है, चूंकि वो प्रैक्टिस एंड प्रोसीजर से डील करता है और अपील के लिए मेरी सबमिशन है मैं एंट्री 55 में जाना होगा, तो जो the part of entry 55 which is actually concerning, I think, everyone here, it is this extent of express authorization. Now, if we turn to Article 184, which is original jurisdiction, that need not detain us, but because it is Article 185 which is relevant here, and in order to see whether this part of entry 55 which says the extent authorization and the extent of authorization in any manner actually applies to the Supreme Court or not, by looking at the language of 184, 85, 86 and then 88. Now 184, there is nothing in 184 which says or which either provides anything or restricts anything. 185, as far as 185 is concerned, 185 also specifically is not saying anywhere appeal can be provided to the Supreme Court from any court other than the High Court or other than the instance other than the High Court. Now,
my problem was that if we read it the way you say it and we read the extent provision with the upper part, so let's take any federal court, koi le le tribunal hai, whatever. So they want to go ahead and do something with it, change its jurisdiction, add to its jurisdiction, whatever. So they'll have to first look at the constitution, see if they express provision, and then they'll do it. So they won't find any.
So they only have to see whether there is any.
That's what I meant earlier.
Authorization.
So they just have to see whether at all there's any limitation in the constitution. If there isn't any, they're free to do whatever they want to do.
And limitation, my lords, would also see there is this High Court's original jurisdiction which is conferred upon it under 199.
Right.
High Court's appellate and other jurisdictions, they flow from statutes.
No, I mean, just take an example that we take any other court which is under the federal legislature and they want to do something to its jurisdiction, add to it, whatever. So they'll do what? They'll first look at the constitution.
So they'll only look at the first part of it because
Right, and then the extent is
they're not constitutional courts. They're not created under the constitution.
So that's nothing to do with this expression. This is only for High Court. Only.
This is only for the court whose jurisdiction, other than jurisdiction, is flowing from the constitution.
No, it
which
says
is
all
190.
courts.
Yes, all courts. But when you look at the constitution is dealing with the high courts, only the original jurisdiction of the high courts. Then the tribunals.
So you say it's limited. This extent.
So
is
in that
limited.
sense, this extent of authorization has to be read only in the context of the court, or other than the Supreme Court to which this entry, this part of the entry is applying, the jurisdiction that the court is from. If it is getting from the constitution itself, then this limitation will apply. But if it is a court which is a creation of a statute with respect to any of the matters in the list, then.
And you say this limitation also applies to a constitutional court because they could, reduce its jurisdiction or could do such a thing, which is not happening in the Supreme Court situation.
Which is not happening in the Supreme Court.
This also includes the Shariat Court. Shariat Court was previously dealing with narcotics cases. Then subsequently, when CNS was enacted, the jurisdiction of Shariat Court was taken away, and now it is with High Court. So it means Shariat Court jurisdiction can also be curtailed by Act of Parliament.
So, with respect to Sharia court, now it says clause 3 of 203DD says such other jurisdiction as may be prescribed in law. Now it is saying that there is a jurisdiction which has to be conferred. With the Sharia court, the chapter provides what matters are to go to Sharia court, what matters can the Sharia court see. So this is all what the constitution is providing. So there is here,
initially all the narcotics cases that will go to the Shariat court. After promulgation of CNS Act, now the Shariat court can't hear those cases, then those cases are applied to the high courts. So it means the jurisdiction of Shariat court has been taken away, and which can be done.
My lord, what we have to see then is we have to examine this chapter and see whether what is
this
provided.
This cannot be done in the case of Supreme Court.
No, it cannot. It cannot be done in the case of Supreme Court because if we look at 185, my lord, look at 185. Now 185, unless we read enlargement part independent of the preceding part, then does not permit any appeal coming to the High Court from either the Competition Tribunal or the election tribunals or all the other instances where appeal has been provided to the Supreme Court, because 185 there is no express authorization.
If you read it the way you're saying, then all those other.
ये 185 में सुप्रीम कोर्ट के ऑर्डर का जिक्र है.
सुप्रीम कोर्ट के ऑर्डर का सर
जी
सर उसमें
देखिए बात ये ना, अगर आप कह रहे हैं कि जी इनलाज कर रहे हैं आप जुरिस्डिक्शन को, तो एपलेट जुरिस्डिक्शन 185 में दी हुई है जी, ठीक, उसको इनलार्ज कर रहे हैं आप. तो अब आप सोचें, आप कॉन्स्टिट्यूशन के एक प्रोविजन को वहां पे कर रहे हैं, ये थोड़ा सा
उसमें
या तो आप सिर्फ ये बता दें कि ये जुरिस्डिक्शन पार कौन से हैं जो नहीं हो सकते 55 के नीचे.
When it says enlargement of jurisdiction,
रिवर्स लेना, आप तो एक्सेप्शंस पे जा रहे हैं, एक्सेप्ट सुप्रीम कोर्ट, व्हेन एनलार्जमेंट है हम उसको रिवर्स में लेते हैं. आप स्टार्ट करें जहां से वो स्टार्ट कर रहे हैं कि आप पावर नहीं कर सकते सुप्रीम को. वो कौन कौन सी जुरिस्डिक्शंस हैं जो नहीं कर सकते,
जो एनलार्ज नहीं कर सकते?
नहीं.
So I haven't got.
आप 55 को प्लीज जरा पढ़ लीजिए.
Jurisdiction and powers of all courts. There's a comma then, except the Supreme Court.
So you can't create jurisdiction or create any new powers of the Supreme Court. Fine. So अब जब आप enhance नहीं कर सकते, reduce
enhance कर सकते हैं,
वो आप कैसे कर सकते हैं?
ये सर ये
नहीं, वो आप देखिए ना, वो तो आप कौन सी एक jurisdiction होगी जिसको आप enlarge कर रहे हैं ना?
Yes.
कौन सी jurisdiction को enlarge कर रहे हैं?
Appellate jurisdiction को enlarge कर.
यानी आप 185 में 184(3) की provision को ला रहे हैं?
तो हम ये कर रहे हैं कि because 185 में ये limitation नहीं है, because 185 में अगर ये हो कि for example 185 had said that in addition to what it says,
फिर देखिए, फिर इसको देने की जरूरत ही नहीं थी. देखिए फिर तो आप किसी भी सुप्रीम कोर्ट की प्रोविजंस दी हुई हैं, तो आप किसी प्रोविजन को भी एनहांस, यानी फिर तो आप हमें वो फिर तो देयर इज नथिंग लेफ्ट टू इट.
इसको इस तरह से अगर देखें, अगर सिंपल ये होता एक्सेप्ट द सुप्रीम कोर्ट एंड the entry had ended where it says authorized by or under the constitution, full stop, then we could not do anything.
नहीं, इसमें जरा मैं ऐड कर दूं कि ये जो अभी कर रहे हैं अपील, this is 184(3). So I raised this question earlier that if you provide an appeal in 184(3), it is not conferring a new jurisdiction, it's enlarging the jurisdiction of 184.
So that could be one way of looking at it, that you enlarge that jurisdiction and then you apply an appeal and there is no limitation under 185.
Where
no limitation under 185
article of the Constitution providing an appeal, and that specific article is intact, it doesn't provide an appeal, then you cannot provide an appeal in another article by under the scope of enlargement. Because appeal is a separate jurisdiction.
So you read 184 and 185 together and see whether there is any limitation. Where there is a jurisdiction which exists and you extend it.
185 jurisdiction is not a jurisdiction in the form of an intra-court appeal against an order of the Supreme Court. So there's a distinction. Now here there is already an existing jurisdiction under 184(3). That is simply being enlarged.
My lord, you read both of them together. I'll just, that's what I wanted. My lord, with this, I think one last question I have to address. Ladyship, you had a question about full court.
अगर आप conclude कर लें तो बेहतर होगा.
बस मैं वो full court वाली बात. Yesterday, Mr. Faisal Siddiqui had made submissions.
ये इसमें Mr. Attorney General, ये section 6 जो है, right to appoint counsel of choice.
जी. जी.
इसका क्या मकसद है?
My lord, this is something which can easily be addressed. Now, of course, you have Order 26, Rule 6, where in exceptional circumstances you grant this power. As
नहीं, यहाँ अगर आप right उसको to appoint a counsel of his choice, तो इसका मतलब ये है कि कोई नया जो वकील आएगा वो full fledged argument करेगा, तो जो spirit of review है जो कि अभी तक settled हुआ है by this court, वो तो खत्म हो जाएगा.
This can be easily dealt with, as I was submitting, with the use. Now, my lord, with this provision,
वो तो
my lord can.
Section 8 में लिख दिया हुआ है ना, it is to override any judgment of any court, including the Supreme Court or High Court.
उसको मैं एक्सप्लेन भी कर देता हूँ, उसको ये भी एक्सप्लेन कर देता हूँ कि नाउ दैट विद द एडवेंट ऑफ टेक्नोलॉजी, एक तो ये कि ट्रांसक्रिप्ट्स बन जाती है, बट लेट्स लीव इट दैट असाइड. With this provision in mind, my lords can suitably amend Order 26 to say require the counsels to file their written briefs, for example. In addition to the pleadings, they file their written briefs.
That is already given
so
in
that
the
will
Supreme Court rules, and that depends upon the court. If feel like.
So इसको अब रेगुलेट करने के लिए, फर्दर करने के लिए कि इसको कैसे इफेक्ट देना है, उसका ये तरीका हो सकता है.
इसमें तो you have given it as a right.
जी, मैं वही कह रहा हूँ कि ये right now, this is a right at one end and there is a difficulty that you have just pointed out of the court at the other end. उसको बैलेंस किया जा सकता है.
अपील किया किसी और ने, रिव्यू दायर किया किसी और
ने, मैं उसी को एक्सप्लेन तो कर रहा हूँ.
वो कोर्ट के सामने फिर शुरू से
मैं यही मैं कह रहा हूँ.
सेकंड अपील
मैं यही कह रहा हूँ कि then the court will go by the वो written submissions हो सकती है. This is something which I appreciate the difficulty that you are pointing out.
Would that be a review stricto sensu, or that would be second appeal?
No. I mean, if it is in review, obviously for determining the review or deciding the review, the principles of review that you have in Order 26 will apply. Now, the only difficulty that my lord has pointed out, there will be a different counsel arguing that. I think in order to give effect to this section, Order 26,
fresh argument of the case.
वो उसमें my lord आप Order 26 Rule 6 में ये amendment कर दें कि जी beyond written pleadings nothing new would be entertained, and that will take care of everything.
Learned Attorney General, even if another litigant exercises the right of engaging a new counsel, he would be still bound by the same principles laid down by this court.
Yes, and
so he can't go beyond that.
So on judicial side,
when we allow a new counsel to come, he also stays within the limits of the jurisdiction.
He is bound by the pleadings which are before the court, and that would resolve that difficulty of a new person coming in, not being part of original proceedings. That might just resolve the difficulty.
Mr. Article 10 of the Constitution gives power gives right to a person to appoint a council of his own choice. How bar be put on a person that you should not appoint a council of your own choice? वो कहते हैं आज मैं ये वकील पद है मैं दूसरा रखता हूँ.
इसको फिर ये वही इसका जो बैलेंस है my lord, वो बैलेंस ये हो सकता है कि आप अब जैसे कोर्ट रूम नंबर 1 I don't know if it is true or not, but there is a transcript of the proceeding.
There was some sense when this rule was made. There was some sense, but with this it will just expand the burden which is already shoulder of this court.
My lord, as I said, आप जो इसमें एक डिफिकल्टी जो मुझे आपके जो ऑब्जर्वेशन से नज़र आ रही है वो ये है कि नया वकील आके कोई नई बात ना करे जो पहले नहीं हुई. यही डिफिकल्टी हो सकती है इन ऑल. सो उस पे इफ रूल 26 जो रूल 6 है इम्पोर्टेंट 26
पता कैसे
आप
चलेगा? देखें ना, वही वकील आता है तो उसको तो आप ये कह देते हैं कि भैया आप पहले आर्ग्यू कर, नया वकील आएगा उसको क्या पता पिछले वाले ने
क्या. So you bind them by the pleadings which are already on the record.
अगर मजे की बात ये है कि ये वाला प्रोविजन नहीं चैलेंज कर रहे हैं, वो कह रहे हैं ये ठीक है. वकील कह रहे हैं इधर तो हमारी फायदे वाली बात है.
Your ladyship, if I may now address that question that you had asked, it's a question that you raised from the first hearing, and it has troubled many that what becomes of that right when there's a full court hearing this matter. My friend Mr. Faisal Siddiqui had also made submissions on this, so I adopt the submissions that he had made. This is not something which is which can easily be addressed because as far as a particular court is concerned, if the entire court is sitting, conceivably there can't be any appeal because there is no one left to hear the appeal in addition to.
No, but the question I think has been perhaps, with all due respect, misunderstood. The thrust of the question is not that. The thrust is that if there is a substantive right of appeal, and right of appeal is always substantive, that right vests when the petition is filed. 184(3) petition is filed, the right vests on that. That is the settled law. Now, the thrust of the question is this. Because of this reason, and a right of appeal has to be mandatory, the power or the ability of the Supreme Court to fix, whether exercised by committee, collegium, whoever, to fix a matter before any bench of strength greater than, as presently constituted, 7, has been taken away. Because the right of appeal, being a substantive vested right, must prevail. So this is an encroachment upon the independence of the judiciary, that no bench, full court, तो बड़ी दूर की बात है, 9 member, 8 member, 10 member, 11 member, keep on counting, cannot be constituted. The hands of the court have been tied, even if it is a matter of the utmost national importance. It cannot be heard as presently constituted by more than 7. This is the question. Not कि full court बैठेगी तो full court में तो 60 के अगर 60 जज हैं तो 60 जज होंगे. Well, obviously बात है. That's not the thrust of the question. The thrust of the question is, which the question has been asked by my learned colleague from Japan. You are affecting the independence of the judiciary to hear matters in respect of, you've put a maximum cap, nothing beyond that. You can't go beyond that. Why you created this right of appeal? इसका क्या जवाब?
और इसके साथ
can it be,
just add on to this question?
If I may just say something, can it not be without taking extreme positions, be very reasonably resolved by saying we haven't prohibited a full court from ever meeting, nor is the law said so, nor that it should not be over a certain thing. We have spelled it out. If you, in your wisdom, which is the Supreme Court of Pakistan, considers to constitute a full court, so be it. So why could it not be resolved simply by saying this?
But can the whole point is that it's a substantive right, access to justice. So the Supreme Court in its wisdom can say, too bad to your access to justice and substantive right. In our wisdom, the full court will sit which means whatever we decide, no appeal against that. So the question is that can the Supreme Court do that? When the law provides a substantive right, can the Supreme Court deny that right? Or when you deny that right, there is no issue with it, so we in our wisdom can decide that? And that goes to the whole point of this law कि आपने कोई wisdom को question किया है, अभी यहाँ पे कोई problem नहीं हो रही wisdom के साथ.
Let me just briefly respond to this in addition to what my Lord the Chief Justice has just observed. This situation of this sort, and I'd come to what Justice Munib Akhtar has observed, this situation could also have, a similar situation could have arisen in these proceedings. For example, if somebody had, let's say, committed a judicial contempt in these proceedings, hypothetically, what would have happened? Now, it had to go before some judge. Now, if it had, because it had happened before the entirety of full court, it could not possibly go before a
That's
judge.
not a vested right, right?
I'm coming to
Right
it.
of appeal is a vested substantive right.
I'm coming to it.
You think, are you Attorney General Saab? I'm sorry to interrupt you. आप contempt of court, ये वकील या पार्टी का right है to commit contempt of
तो आप डायरेक्ट एग्जांपल दे दें ना, अटॉर्नी जनरल आप डायरेक्ट एग्जांपल दे दें कि ये केस इस केस की अपील कहाँ जाएगी. आप मफरूजों पे क्यों चल रहे हैं? ये भी तो हम केस सुन ही नहीं रहे ना. कोई ना कोई हमारे फैसले से खुश नहीं होगा, शायद सब ना खुश हों, हमें नहीं पता. उनकी राइट ऑफ अपील तो है ही नहीं. तो ये कानून ने कहाँ कहा है कि हर केस में अपील होगी? उन्होंने कहा एक किस्म के केसेस में जहाँ कम है वहाँ अपील होगी, राइट ऑफ अपील. कानून ये नहीं कह रहा है कि कानून ने उधर गए ही नहीं है. कानून उस जगह गए ही नहीं.
Let's read section 5. Please read it to see कि कानून क्या कह रहा है और किसको राइट दे रहा है. पढ़ें प्लीज section 5.
जी. An appeal shall lie within 30 days from an order of a bench exercising jurisdiction under clause 3 of article 184 of the Constitution.
184(3) की अपील लाई करेगी. इसमें तो कोई हमें confusion नहीं है ना.
It shall be read, will be may. It is very simple. I mean, why do we have to? I mean, we have done it in so many cases.
One submission to this.
Again, let me make one question to you. The fact that in this case, the full court is hearing the virees. Okay? In this case, if the law is struck down, बात खत्म हो जाती है. मैं section 5 बोल. If section 5, if the law is declared intra vires, I would find it some rather odd for a petitioner to say, I exercise the right of appeal under section 5 for a declaration that the law including section 5 is ultra vires. So this particular case is an exception because here the very vires of that act are under attack, including section 5. इधर वो नहीं बात apply कर सकती. बात हो रही है if this law survives challenge, तो फिर जो सवाल है separation of powers और independent judiciary का कि आपने एक मैक्सिमम कैप लगा दिया जी 7 से ज़्यादा नहीं सुन सकते क्योंकि आपने एक सब्सटैंटिव वेस्टेड राइट दिया हुआ है. उसको किस तरह कोई कोर्ट एक किसी का राइट है वो टेक अवे कर ले बाय एडमिनिस्ट्रेटिव एक्ट. इज दैट व्हाट यू आर आर्ग्यूइंग?
Let me confess my mistake to constitute a full. It should have been less than the half of the number of judges of the court, so the right of appeal, if the law was sustained, would have remained.
No, I said
let me finish my thought. Would have remained, so I am certainly guilty of that. But then I'm not alone in that. Then my colleagues should not have sat in the bench at all. And they did so when 8 of them, us, were also sitting. Then the same question was, if this law we sustain, where will the right of appeal go? So that is not your fault. If at all a fault has been committed, I'm the first to accept my mistake to do this, but there was in need of transparency and in need of a demand. It was done, and nobody objected amongst my colleagues that the full court should not be constituted. Similarly, I assume that none of them objected when 8-member bench was constituted. There too the right of appeal had disappeared. So effectively that had become redundant. They should have said, no, we will not sit let a lesser bench be constituted, because if this law is sustained and if someone is aggrieved, where will his right of or her right of appeal go, or the government's right of appeal, or a political party's right of appeal. So इन मफरूजों से निकलें और conclude कीजिए, आगे खत्म करें, हमें सोचना भी है, करने भी दें.
Mr. Daniel, let me clarify for you, Mr. Daniel, this is not a mafruza. I have said that this particular case is a special case in the sense and for the reason the very vires of this law are under challenge. It is not possible that if this law is sustained, for a party challenging the very vires of the law to say, I exercise the right of appeal under section 5 for a declaration that this right of appeal that I have exercised is ultra vires the constitution. That would be completely nonsense. I am speaking of the future. I am not speaking of this case. Because here the vires are under attack.
My lord, my brief response is this.
Suppose अगर ये law sustain कर जाता है, तो this issue can be resolved in the full court meeting. Rules में हम बना देंगे कि benches होने चाहिए या नहीं होने चाहिए. अगर full court होगा, तो उसके बाद है.
इसमें मेरा response simply put and I'd conclude.
Said, I mean, the law, through the rules, the law cannot be changed. That is your position.
So there's nothing that can be done. This issue, you see, this goes, if you flip it around, if you, एक second, flip it around and you don't see it as a vested right, because as in an opinion has been given, it doesn't matter about the vested right. So we flip it around and we see it in the context of what can the court do and what can't the court do. So you have actually capped in order to ensure that the right is always given to a party who files 184(3) petition, you have ensured that a certain quantity se zyada badi bench nahi banegi, depending on the strength of the court. Now, is that not some sort of an intrusion on how the court is to work? I mean, is that not something that the court has to decide based on factors that the court understands best?
No, I don't.
Whether this precludes the other part of the judges not to hear the matter. The matter was heard by some judges in the first instance, then it was heard by the other judges in the second instance.
In practical,
the entire judges have heard the matter.
And I think this right, I think it is a right being conferred on, and I had briefly shown your lordships that
why are you putting it on us? Why are you putting it on us? Either you say, yes, please, there is a right, you cannot now deny anyone this right. Don't tell us that you have hope and faith. Please do that accordingly. Please be precise in what you want to say.
Let me make your life easy. I put it upon myself. Let's end it. I take responsibility. Let's move forward. You've concluded the case or not?
I have, okay, my lord. And I'll just say this.
So I first of all, let me compliment the petitioners who have fought valiantly to sustain my powers, and and you and the others who want to undermine them. So, but thank you very much for remaining good humor till the very end, despite some very difficult questions. And if we have said anything, or any one of us, which may have upset anyone, we certainly did not intend to do so. Sometimes in the heat of battle, things are said which are not really, don't mean anything. So let us end in good humor. And does it conclude the matter, or is there anything left for us to say or do?
5 minutes, just 2 very quick points.
5 minutes, certainly. Aye.
Grateful, my lord.
Thank you.
Thank you for your patient hearing.
My lord, on a very lighter side, the powers which have been exercised in promulgating this law are 1752, say so. It doesn't say so that 142 has been used, read with entry 55. So my submission is that discussion on entry 55 is little superfluous. And if your lordship may allow me to refer to 175(2),
by now we memorized it.
We memorized it. I know.
Make the point.
I know. The point is that, and I think I would be able to make a better point if I just read, because it has to be read together.
The right of reply, na?
Very, very quickly. There shall be a Supreme Court of Pakistan, a High Court for each province, for Islamabad and such other courts. So the provision is using Supreme Court and the High Court and other courts separately. And if you read 175(2), no court shall have jurisdiction save as is or may be conferred on it by the Constitution or by any other law. So when 175(2) is read along with 175(1), the word court does not include the Supreme Court. And if I may refer to your Lordship's dissenting opinion in the Rawalpindi High Court Bar Association case, where interpreting various provisions of the Constitution, it has been concluded when the Constitution uses the words any court, that does not include the Supreme Court. So my humble submission would be that 175(2), they cannot draw the power to legislate for the purposes of this law for Supreme Court, relying on 175(2).
Point taken.
And Your Lordship, again on a lighter tone, there is a world of difference between will of the people versus the will of the Parliament or will of the government. So that aspect has to be taken into consideration. And Your Lordship,
No, sorry, there isn't any. The preamble starts that the will of the people will be expressed through their chosen representatives, which is the Parliament.
That is what my point is, the chosen, and then modifying the Constitution by the will of the chosen representative has to be by 2/3 majority. So that is what the principal point is. And Your Lordship, again, the point in the same context is that when the Constitution has intended to confer an appeal right, that has been specifically provided by the Constitution, and there is an appeal against in the case of Article 63.
right of reply पे रहिए ना.
जी मालूम यही right of
points आप दोबारा.
मालूम वो मैंने पहले नहीं raise किया था because this is a specific provision, the specific point that has to be taken into consideration. So these are the two major points that I just thought would be relevant, because under 63A, Article 5, 2035 and 2123, there is a right of appeal which the Constitution, there is no right of appeal which is specifically conferred or 184. And my Lord, last point very quickly is that there has been no answer or no argument to counter the point that this committee by section 2 and 3 has virtually modified Article 1843 provision. And in fact, the law itself, as your Lordship was on a lighter tone saying, that if the Honorable Chief Justice doesn't fix the case, then the law itself does not provide that the committee, in how many days the committee will decide that the bench will be constituted, in how many days the committee can also likewise sit down on this. So the law has to really be seen from that perspective. And I think the solution lies in your Lordship looking at the rules themselves rather than any outside body. I'm very grateful, my Lord, for very good.
जी आबिद साहब.
जी आपकी इजाज़त से सर, फेडरल शरीयत कोर्ट की जो बात की अटॉर्नी जनरल साहब ने और माय लॉर्ड जस्टिस मंदोखेल ने, एक प्रोविजन फेडरल शरीयत कोर्ट के चैप्टर्स में कर दूं जिसकी वजह से रूल मेकिंग पावर को सब्जेक्ट टू कॉन्स्टिट्यूशन एंड लॉ नहीं किया गया. आर्टिकल 203A, ये देख लीजिए सर, बिकॉज इस पर सारी शरीयत कोर्ट के मुख्तलिफ प्रोविजंस की बात होती रही, लेकिन दिस इज अ वेरी क्रूशल 203A. Capital A, my lord. The chapter starts 3A. The chapter 3A, 203A. Am I with your lordship, sir?
Yeah.
The provisions of this chapter shall have effect notwithstanding anything contained in the constitution.
Yeah.
तो ये पहले ही constitution को, that's why जो rules
किसने बनाया? वो कह दीजिए ना
सर, लेकिन
हिम्मत कर लेगा.
बिल्कुल बनाया, एक मार्शल लॉ के जमाने बना नहीं, लेकिन सर, लेकिन इसको अपहोल्ड किया और
इसको आप कह रहे सुपरा कॉन्स्टिट्यूशन बनाया.
मैं ये कह रहा हूँ कि 18वीं तरमीम भी तो पार्लियामेंट ने सबने मिलकर बनाई, उसको चैप्टर को रखा.
Endorsement is a different thing as opposed to enactment.
सर मैं सिर्फ बता रहा था कि उसके दैट इज द रीजन कि कॉन्स्टिट्यूशन को बिल्कुल इससे कर दिया. और बुरी चीज है सर, मैं कहूंगा ये कि उसको कॉन्स्टिट्यूशन को इसमें से इस चैप्टर से निकाल दिया गया. सर एक चीज और, आप इजाजत,
आपके ख्याल में फेडरल शरीयत कोर्ट की बनाया जा सकता था, जो अदालतें थी उनसे इख्तियारात ले करके एक अलग पैरेलल सिस्टम खड़ा कर दिया गया?
सर मैं कह बिल्कुल, मैं एक पैरेलल सिस्टम जरूर खड़ा किया गया, लेकिन अगर कोई पैरेलल सिस्टम
आईनी तौर पे सही गलत ये बताएं.
आइन तो सही है सर. तो आइन जो पढ़ा जाएगा वो, मैं 3 आपसे बात की जब मैंने वो जजमेंट भी साइट की थी, 175 142A और एंट्री 55
तो
ये
आप-
तीनों चीज सर
ये
एक चीज बस
खामोशी।
माय लॉर्ड मिस्टर जस्टिस अफरीदी ने ये सवाल किया कि जो जुरिसडिक्शन वेस्ट करती है इन द सुप्रीम कोर्ट वो अपेलेट जुरिसडिक्शन अलग होती है, ओरिजिनल जुरिसडिक्शन और एडवाइजरी जुरिसडिक्शन होती है, रिव्यू जुरिसडिक्शन अलग होती है। एक केस अगर आपकी इजाजत से अगर नाराजगी ना हो
और एक शरीयत अपेलेट बेंच जुरिसडिक्शन भी है
हाँ लेकिन लेकिन मेन जो मैं बात कर रहा हूँ अगर हम क्योंकि हम बात करें अपेलेट सर एक केस हमेशा हमारे मुल्क में हमारे इस ने हमेशा फॉलो किया फ्रॉम द अमेरिकन जुरिसडिक्शन और सुप्रीम कोर्ट ऑफ अमेरिका है दिस टाइम सर मार्बरी वर्सेस मेडिसन वो आपकी हमारे कोर्ट्स ने उसकी जो प्रिंसिपल्स को अप्रूव किया उसमें से अगर आपके पास मेरा मुझे नहीं मालूम ये है उसको मैंने फाइल किया हुआ है उसमें सिर्फ पढ़ दूं कि क्योंकि वहां ओरिजिनल और अपेलेट जुरिसडिक्शन का डिबेट हुई कि क्या पार्लियामेंट को पास इख्तियार था कांग्रेस के पास वो ओरिजिनल जुरिसडिक्शन दे कुड हैव ग्रांटेड अपेलेट और इंक्रीज द साइज तो उसके लिए सिर्फ मैं 2-4 लाइनें पढ़ना चाहूंगा आपको अगर आपके पास ये मेरा
पढ़ लीजिए
जी इसमें 179 पेज अगर माय लॉर्ड हैज दैट बुकलेट व्हिच आई हैड गिवन सर मैं विद योर लॉर्डशिप
पढ़िए
जी इट्स पेज 176 ऑफ माय बुकलेट सर और यही बात जो माय लॉर्ड मिस्टर
पढ़ लें
निकाल लें सर बॉटम ऑफ द पेज लास्ट 10 लाइंस पेज 176 माय लॉर्ड द सुप्रीम कोर्ट शैल हैव ओरिजिनल jurisdiction cases affecting ambassadors or and other public ministers and councils and those in which a state shall be a party. In all other cases, the Supreme Court shall have appellate jurisdiction. This is the American Constitution. It has been insisted at the bar that as the original grant of jurisdiction to the Supreme and inferior courts in general and the clause assigning original jurisdiction to the Supreme Court contains no negative or restrictive words, the power remains to the legislature to assign original jurisdiction to that court. In other cases, those specified in the article, which has been recited, provided those cases belong to the judicial power of the United States. If it had been intended to leave it in the discretion of the legislature to apportion the judicial power between the supreme and inferior courts, according to the will of that body, it would certainly have been useless to have proceeded further than to have defined the judicial power and tribunals in which it should be vested. The subsequent part of the section is mere suffrage, is entirely without meaning. If such is to be the construction, if Congress remains at liberty to give this court appellate jurisdiction where the Constitution has declared their jurisdiction shall be original, and original jurisdiction where the Constitution has declared it shall be appellate, the distribution of jurisdiction made in the Constitution is form without substance. Affirmative words are often in their operation negative of other objects than those affirmed, and in this case a negative or exclusive sense must be given to them or they have no operation at all. So ये मैं आपसे बताना चाहता हूँ कि
जब आपको एक बात सिर्फ बता आपको ये खुशी होगी मालूम हो करके कि हम तो अमेरिकन जूरिस्प्रूडेंस कोर्ट करते हैं और अब हमारे 2 कोलीग्स यहाँ बैठे हुए बेंच पे जिनके जजमेंट ऑन क्लाइमेट चेंज और वो जो हाथी वाला जजमेंट वो इंटरनेशनली कोर्ट होता है सो वी आर मेकिंग इनरोड्स वी आर आल्सो क्रिएटिंग जूरिस्प्रूडेंस व्हिच इज बीइंग कोटेड एल्सवेयर इन द वर्ल्ड
इंशाल्लाह ये भी कोर्ट होगा सर ये जजमेंट भी सर
आपके ताउन से
इंशाल्लाह सर
शुक्रिया
आई एम ग्रेटफुल टू योर लॉर्डशिप सर थैंक यू सर
ओ चौधरी साहब हमने बंद कर दी किताब फिर खोलना पड़ रही है
2 मिनट कुछ भी नहीं पढ़ूंगा क्योंकि जजमेंट तो मैंने पढ़ी नहीं पहले तो ये मैं अर्ज करूंगा कि इस्लामिक हिस्ट्री या जूरिस्प्रूडेंस या उस हवाले से बात हुई तो एक रवायत
ये आप हमें कुछ दे ना उस पे मैं काफी इंतजार कर रहा था कि कोई मिलेगी
मैं करूं सिर्फ 2 मिनट क्योंकि 2 पॉइंट्स हैं जिन पे मैं कुछ कहना चाहता हूं एक तो ये कि अगर 2 लोग भी एक साथ सफर करें तो अपना अमीर मुकर्रर कर लें ये वो प्रिंसिपल है जिसकी बेस पे हमारे यहाँ पैटर फैमिलिया और चीफ जस्टिस के
ये मैं प्रिंसिपल से वाकिफ नहीं
बहरहाल ये रवायत मैंने पढ़ी
नहीं ये ऐसे तो नहीं मानेंगे आप आपको इसका दीजिए कोई हवाला दीजिए
मैं दे दूंगा
नहीं ये आपने ऐसी बात कर दी और कहा ये जैसे कि है
मैं गुजारिश करूं मैं इस पे रेफरेंस दूंगा
अब वो आपने दिया नहीं अब हम क्या करें
जी दूसरी बात
जी
चौधरी साहब अमीर के हवाले से अगर बात करें जी अगर आप कभी तबलीगी जमात में गए अमीर तो मुकर्रर होता है लेकिन वो सबसे मशवरे के बाद अपना फैसला बाद में करता है बगैर मशवरे कोई काम नहीं ये दुरुस्त है इस वक्त ये अदालत जो हमारे सामने मौजूद है तमाम जज साहबान एक स्कीम के तहत यहाँ तशरीफ लाए और अपॉइंट हुए और उसमें चीफ जस्टिस साहब आई वुड वेरी रिस्पेक्टफुली से कि चीफ जस्टिस साहब को एक्सक्लूसिव ये इख्तियार बेंचेस बनाने का और रेगुलेट करने का जो है, इस हवाले से मैं बात करूंगा।
क्या कहते हैं आपके मुंह में गुड़ शक्कर क्या होता है?
वो भी सर, हमें तो बहरहाल आप पसंद हैं। आर्टिकल 191 जो है, इसको बड़े अदब से अर्ज करूंगा कि मैं जो कुछ समझ सका, ये इंजंक्टिव है, ये डिसजंक्टिव नहीं है। इसको अगर इलाजा से पढ़ेंगे तो इसका मतलब ये होगा कि वो लॉ जो है, लॉ वुड टेक अवे एनीथिंग whensoever the parliament deemed it fit to enter into the domain of the Supreme Court in making rules and regulating its affairs. So इस पर्टिकुलर प्रोविजन को इस जागे से भी काइंडली देखा जाए। और एक बात और जरूर, ये चीफ जस्टिस साहब के स्टेटस के हवाले से, अल जहाद ट्रस्ट केस बजाते खुद जब सीनियरिटी,
जो साहब का लफ्ज है ना, मुझे पसंद नहीं है।
चलिए जी,
मैं चीफ जस्टिस कहते हैं मेरे लिए काफी है।
दुरुस्त। वैसे तो हम एहतराम में,
नहीं एहतराम में नाम के साथ
माई लॉर्ड भी कहते हैं,
काजी साहब वाइस साहब कहते हैं, मतलब
तो माई लॉर्ड भी कहते हैं।
मत कहें
जी,
चले आगे।
लेकिन बासूरत ये एहतराम चल रहा है सर। इसमें अल जहाद ट्रस्ट में जो सीनियरिटी का केस तय हो गया कि आपने सीनियर मोस्ट जो है उनको हाई कोर्ट्स में और सुप्रीम कोर्ट में चीफ जस्टिस मुकर्रर करना। बाकी चीज़ों के अलावा बेसिकली उसमें भी आइडिया यही था कि वो जो इंटरनल रिफ्ट्स हो सकती हैं, इन्फ्लुएंस फ्रॉम आउटसाइड हो सकता है एग्जेक्टिव का, उसको अवॉइड किया जाए ताकि स्मूथली कोर्ट्स जो है वो अपना फंक्शन जो है वो अदा कर सके। तो मैं ये गुजारिश करना चाहूँगा कि चीफ जस्टिस का इस्तेकाक एज चीफ जस्टिस विदाउट द ऑफ कोर्स the committee which is being suggested, that may not be serving the cause of justice. That's all.
सर एक बात करना
जी जी,
ये 143 में चीफ जस्टिस साहब का जो इस्तेकाक 73 से लेके आज का चलता रहा है, उसके खिलाफ तो आप लोग सड़कों पे रहे हो
जी जी,
और आपको पता है कि जब अपनी मर्जी का बेंच बनवा के जिस तरह वैलिडेट किया जाता था डिक्टेटर्स को, उसे को तो आप सड़कों पे थे। आज जब 1 से लेके 3 को दे दिया, कलेक्टिव विजडम कर रहे हैं, आप कहते हैं जी ये बहुत गलत हो रहा है। ये क्यों कह रहे हैं?
ये एक
ऐसा
बात
क्यों किया जा रहा है?
देखें,
देखें, आपको हमने कुरान भी पढ़ के सुनाया,
जी जी,
वहां भी लिखा हुआ एक अपील का राइट है, कुरान भी पढ़ के सुनाया, जहां कि आप एक कलेक्टिव ऑफ विजडम करके मशवरा करके कर सकते हैं। अगर इसके मुताबिक अगर पार्लियामेंट ने फॉर द फर्स्ट टाइम एक लॉ बना दिया उस तमाम डिक्टेटरशिप को रोकने के लिए, तो आप कहते हैं जी ये बहुत गलत हो गया है। इसका बनना ना बनना एक अलग एस्पेक्ट है, वो आपने सुन ली सारी बहस, उसको हम फैसला कर लेते हैं। लेकिन इतना तो कहें कम अज कम कि ये लॉ ठीक बना है। आप भी कहते हैं नहीं जी रहना चाहिए, एक चीफ जस्टिस को रहना चाहिए। आप डिक्टेटरशिप को ना प्रमोट करें। क्या हम गुलाम हो गए हैं सारी, जब से ये इस मुल्क को 4 दफा इन लोगों ने किया, आखिरी मुशर्रफ ने किया, क्या जुल्म किया हमारे साथ?
अगर इजाजत
को चलने दिया ही नहीं।
मैं इस कंट्रोवर्सी में नहीं जाना चाहता।
इसको देखिए, इंपॉर्टेंट चीजें, ये हमारा मुस्तकबल है।
मैं ये
अच्छा मैं सिर्फ ये कहना चाह रहा हूँ,
थोड़ा सा
हम जरा इसमें डिस्कशन करेंगे। अगर इत्तेफाक राय हो जाती है या कोई क्लैरिटी आ जाती है तो हम अनाउंस कर देंगे, नहीं तो फिर रिजर्व होगा। ठीक है, अगर अभी हमें नहीं पता, आपस में हमें बात करना होगी कि कैसे हो रहा है, तो मैं कुछ कह नहीं सकता हूँ। वी रिटायर, अगर जरूरत पड़ी वापस कन्वीन होने की तो कर देंगे, नहीं तो आपको पैगाम भिजवा देंगे। ठीक है,
थैंक यू,
शुक्रिया।